Justice, the Venerable Justice Dotse, Acting Chief Justice.
We should be celebrating him today.
Yes, let me just celebrate.
We should be celebrating. We should be playing. We should
Bobo.
You should do a Dotse. Government in another world, you do Dotse's playlist.
Thank you.
Today is bowing out. His top 10 songs. Then you call him and you laugh. Just enjoy. Just have fun. Then you say, I like. Then you tell that he likes something. Say, you like this? So he likes Lumba. Say, you like Lumba? Something like that. Then you'll be happy.
Yeah.
You can still do it. Charlie, the system is economically difficult.
Yeah, so there should be some Bobo song we play for him sometime later. But there's a reason.
No, you can't.
There's a reason. Just I want to.
But do you know what kind of music he likes?
There's no way he would not like Bobo because it's from Kwando and.
Okay.
Bobo, Akpe said yeah.
Oh, okay.
Yeah.
But confirm it first.
Oh,
But then you'll be surprised.
How can you be?
Maybe he likes jazz or something. It will shock you.
One thing that is very sure, if you play him the Accra Academy anthem, he'll be happy.
Oh, it's an Ableobi.
Yeah, that's a
But how can you produce so many judges and lawyers and Charlie, Accra they monopolize the legal
parliamentarians
profession. Are you serious?
speakers and
72, I think.
Is he older than Doa Jaho or younger?
no, he's older. He's older.
They've produced all kinds of
Retired today on 70.
legal minds. I think Alajit is also a cracker.
Yeah.
And then there was also
DF
Anand is a cracker. Doa Jaho is a cracker. A lot of them, a lot of legal brains.
Yeah, and the reason I celebrate him is that he's contributed so immensely to enriching the law and the use of our constitution, and then also extending the boundaries of many rights that people enjoy today, although guaranteed by the constitution.
So, which are some of the cases he did?
So, for instance, in the Mensa and Mensa case, which I think Godfred mentioned it yesterday, hitherto the law of Ghana was that if a man acquires property during the pendency of marriage, that property belongs exclusively to him.
Okay.
So the kids may contribute, the wife may do anything. It is just the normal operation of marriage. At that time, Olenu laid down that rule much earlier. Then came the principle of substantial contribution.
Okay.
So the judges then developed a theory or a principle that the woman must prove, or the spouse must prove, that when this property was acquired during the pendency of the marriage, he or she contributed substantially to it. So that contribution could be in the form of you maybe, fetching water as they were building the house, or you using your money to buy roofing sheets and all of that. But then there were criticisms around it because many women were going home without anything at the end of marriage. And the concern was that why are you creating a situation where women stay at home, they bathe their babies, they
also contribute to the family.
Exactly.
But because they are not earning a direct income, they don't get anything.
And then in the Mensa v. Mensa case, Justice Dotse used his legal industry
in all his glory
to actually give effect to Article 22 of the Constitution by expanding the principles which we now call, equality is equity. So that the starting point is that at any point during the marriage, when property is acquired, the presumption is that we are going 50-50.
Okay.
Do you understand? So because the framers of the Constitution said that.
So what is yours is also mine.
Yeah, that's right. Now it is but the principles of equity would apply. So, for instance, if you, Bernard, contributed more to the acquisition of the property,
you get a substantial more.
Exactly. And that has, to a large extent, saved many women.
So that is the Mensa versus Mensa
cases. There have been several other decisions that have been developed on that particular principle.
And this is within the remit of family law.
Family law. And so women who are in abusive relationships, women who are struggling to support the family,
or in a strange relationship,
when something happens to the relationship tomorrow, and there is evidence to prove that a particular property was acquired during the pendency of a marriage, then they can go to court.
But this was he in the Supreme Court, or he did this as a High Court judge?
No, it was the Supreme Court. It was a case that traveled from the lower courts to the.
And this was his judgment.
Yeah, that's right. And he decided it.
And it's become precedent now.
Yeah, it's a locus classicus in many respects. And then also, he also gave effect to Article 18 of the Constitution on Privacy.
Okay.
And the case of Aka versus ADB. Now, that case concerned a woman who was at the time working with ADB. I don't know if she's still working with them now. And, in the heat of some reforms at ADB, a friend of hers recorded her.
Hey.
They were having a conversation on phone, and then a friend recorded that conversation about the reforms and her misgivings. She was a senior most person or a senior.
So it's a private conversation.
So the person secretly taped the conversation and handed it over to management. This is what your senior person is saying about the reforms you're doing, which was gross violation
of their privacy.
Exactly.
So the matter, what happened?
So she was fired. They had a disciplinary committee hearing. She appeared, and subsequently they removed her from office. And she got, disturbed, and she filed an action. It traveled to the Supreme Court, and Justice Dotse and the rest of the team did justice. By expanding the frontiers of Article 18, giving effect to it.
So essentially, her rights were violated.
Yeah, that's right.
And that evidence was wrongly procured.
Exactly.
So for the people to use it to sack her cry, it's not even fair.
What's wrong? So from that principle, you cannot now, if I'm talking to you, Bernard, on phone, some people have auto record on their phones. So when you're talking to them, the moment you call them, the recording has started. So whatever conversation you have with them, you record it and then you send it out. I can sue you when you do that, because in consenting to the conversation with you, I did not at any point say that you could record me. The only basis upon which that recording can be taken in as evidence in a valid way is where, for instance, I'm planning to do a coup d'etat, knock on wood,
or something which is subversive to the state.
Exactly.
National security issues.
Yes.
Otherwise, you have violated a person's rights.
That's right.
That's interesting. That's interesting. So, I mean, I'm happy what you're doing, because I feel like sometimes, there are in Ghana now, because of the way the media works, a lot of people who get prominence don't deserve it. And a lot of people who deserve to be celebrated don't get to be celebrated because they don't cause controversy. And I blame myself and other journalists for this, because in seeking for news, there are very effective people who contribute to our society who will not do interviews or who will not even be highlighted. And the fact that they don't do interviews doesn't mean we shouldn't talk about them. So you find out that many people occupy the prominence in public discourse just because they are politicians or because they are some lawyers. But you're right that for somebody who served on the bench for this number of years, who has helped to shape our jurisprudence in this very intricate way, who will not necessarily go and do a self-serving interview because of the way he was trained. It's good for a journalist lawyer to go through and say, here are some of the cases he did. All right. Now, the Bando secondary people are saying that he did Form 1 to 5 there, so we shouldn't take them out of the conversation. So, in fact, a person's secondary school is the place they went from Form 1 to 5.
Oh, I see. Not
Sixth form is just an addendum to their education.
I see a footnote.
So, Neta, Opan is a pasek be a.
No, but we
Doche Amenoni.
will not.
Chikwa Wononi.
We will not argue.
That's
fine. That's okay.
Doche.
We will not argue about that. The point really is that if you go through Akraka's annals and records,
he's there.
You'll find Jones Dotse's name there. That is fact. And we will not argue against such facts. Yes.
And also, but let me also quickly mention that he's also decided an important case that clarified the law on what is canal knowledge. Previously,
again, Supreme Court?
Yeah, that's right. This was was about some police officers who apparently forced a woman into having sex. They basically raped a woman. They dragged her into a room and just raped her.
In Ghana?
In Ghana. And
how far back was this?
This was decided. I don't immediately have
okay.
But it was it should be the early part of 2000. Yeah,
so it's quite a while back.
Yeah, quite a while back. Yeah, that's right.
And then he clarified the definition of carnal knowledge.
Yeah, that's right. That it doesn't matter how deep. you go or how trifling it
Slow.
may be. Yeah, I know. Yeah, so because kids are listening.
I see. So Dotse has a lot. I didn't know this.
Oh no, I mean when it comes
Of course, you lawyers know these things, but we don't. It's not our bread and butter. But
the problem is
It's also very prominent on the NGO scene, actually.
is it?
Yeah.
Tell
the
me about
legal
it.
side. You know.
Oh, okay.
Yeah. He's been a fervent supporter of a lot of this project that was freeing people. The remand one.
Oh yes, the Justice for All program.
Program that was he used to go around.
Okay. My question though was, who are his mates in the legal? You know, law, they have these things they call like
They're like
his
cohorts.
year group. It would be nice to know, because, for example, I remember when Aikoto appeared before the Supreme Court in the Sir John case. We were pleasantly surprised to know that his mates were most of the guys on the bench, and also sometimes when they are doing cases, they'll say, "Oh, Chachu taught this guy." So those things are very. It's not known to us, but it would be nice to know some of
My
this.
father's year group is a very interesting one. We'll discuss it later.
Who is there? So is he senior to this man?
Yes.
Your father, yes, your father.
The head of the DC of the General Legal Council.
Yes, his cohort. I think there are 2 Supreme Court justices there.
Okay.
There's the president there.
Okay. So this is 19. This will be 19. This is the year they are called to the bar.
Yes.
The year they are called to the bar.
Yes.
Sky, do you know when Dotse was called to the bar?
Dotse was called to the bar in the. Hold on, let me.
Because today is 2023.
That should be in the. Hold on.
This one I have to check.
Yeah.
By the way, he also created the term "create, loot, and share,"
Yes.
which I think is a very wonderful way of describing the kind of corruption we've seen in the Fourth Republic, where people scheme to create something that didn't exist. They take the money and then they share it among their friends, and they all keep quiet. So we thank him for create, loot, and share.
But I'm happy we're able to discuss this because, you know, when the vetting of Justice Okonu was going on, and in fact this came up when, you know, recent vettings of Supreme Court justice came up, and listeners, for instance, were asking us why we are unable to talk about some of these things as Sky is mentioning, some of the cases that they are known for. What are the principles that they stand for? So, for instance, if we were to do a US version or a UK version, you would know that this person is this kind of person. If this kind of case goes, this person's history of rulings show that this person is this kind, has this kind of philosophy.